Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 21 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between November 4th, 2020 and November 10th, 2020. There was only one noteworthy case this week addressing an adjudication of delinquency in a juvenile criminal matter. In the interest of CB is an appeal following an adjudication of delinquency for viewing and or possessing child pornography. The defendant was charged with child pornography after over 100 images and videos were found on his school computer after he dropped it off for repairs. After an adjudicatory hearing, he was found to have committed one or more of the acts of possessing and viewing child pornography. Approximately 2 months later, the court held a hearing to determine whether the defendant was in need of treatment, supervision, or rehabilitation. The defendant presented the testimony of his licensed professional counselor who indicated that the defendant had participated in 11 sex offender therapy sessions and that he was currently a low risk to reoffend and was not in need of further treatment. The defendant also presented testimony by a probation officer who testified that because the defendant had successfully completed the treatment and had no more existing issues at home or school, he was considered low risk to reoffend. The probation officer testified that if the defendant were adjudicated delinquent, he would recommend probation supervision. Finally, the testimony of a psychologist who concluded that the defendant presented a low risk for sexual recidivism and does not require any further treatment for restrictions for sex offender risk. The Commonwealth did not present any witnesses or evidence. At the conclusion of the hearing, the court found that the defendant was in need of supervision and adjudicated him delinquent on all counts. The defendant timely appealed. The issue on appeal is whether the court abused its discretion when adjudicating him delinquent when the testimony presented at the hearing showed that he was not in need of further treatment. The Juvenile Act grants broad discretion when determining an appropriate disposition, which will be disturbed only upon a showing of a manifest abuse of discretion. An adjudication of delinquency requires the juvenile court to find that the juvenile, 1, has committed a delinquent act, and 2, is in need of treatment, supervision, or rehabilitation. A determination that a child has committed a delinquent act does not, on its own, warrant an adjudication of delinquency. After determining that a juvenile has committed a delinquent act, the court shall then hear evidence as to whether the child is in need of treatment, supervision, or rehabilitation as established by a preponderance of evidence. Finally, in the absence of evidence to the contrary, evidence of the commission of acts which constitute a felony shall be sufficient to sustain a finding that the child is in need of treatment, supervision, or rehabilitation. In this particular case, the court determined beyond a reasonable doubt that the defendant committed the delinquent act of viewing and possessing child pornography. Then, at a subsequent hearing, it was determined that he was in need of supervision, rehabilitation, or treatment, and he should be adjudicated delinquent. Here, all of the defendant's issues boil down to one main contention: whether the trial court erred in finding the defendant was in need of supervision where it was contrary to the evidence presented at the adjudication hearing, the Commonwealth did not present any evidence that the defendant was in need of supervision, and the evidence presented by the defendant rebutted any presumption that he was in need of supervision. On appeal, the court found that the juvenile court came to a reasoned conclusion that the defendant was in need of supervision. The juvenile court based its conclusion on the fact that the defendant, had he been tried as an adult, would be facing up to 700 years of incarceration. The court notes that the adult system is a completely different animal, but the possible sentence reflects on the severity of the offense. Further, the court noted that the defendant had a special interest in computers, and as such, continued supervision is necessary to ensure that he maintains his current success. The court essentially said that the testimony presented at the hearing suggested that he was not in need of any further treatment. The court agreed with that proposition, that no further treatment was needed, but that he was in need of continued supervision. An adjudication of delinquency looks at whether the juvenile needs supervision, treatment, or rehabilitation. The Commonwealth need not establish, and the judge need not find that the juvenile is in need of all three. A finding that the juvenile is in need of any of the three is sufficient. As the appellate court found no abuse of discretion, the adjudication of delinquency is affirmed. The most important thing to keep in mind when handling a juvenile case is how dramatically it differs from the adult criminal justice system. It is really a system that focuses heavily on rehabilitation and is a two-phase process. First, being whether the act was committed, and second, whether the juvenile is in need of supervision, treatment, or rehabilitation. In the adult system, there is only one phase, guilt or innocence. While needs for treatment and rehabilitation are addressed in adult court, they are secondary to the actual guilt or innocence, unlike juvenile court where they take center stage. There were a handful of other cases decided this week addressing zoning issues in adoption, but for brevity's sake, they are not addressed here. The full text of each case is linked in the comments. Thank you again for joining us for the podcast this week. We hope you have a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.